We begin with jury selection and the trial of a former police officer accused of killing Daunte Wright. It starts today. Warning, the video we are about to show you might be triggering and hard to watch for some. And jury selection actually started yesterday. We paused that video right before that deadly shooting, which took place in April. Now, Wright was shot after being pulled over for an expired license plate and having an air freshener hanging in his rearview mirror, which police claimed obstructed his view. The former Minnesota police officer claims she mistakenly grabbed her gun instead of her taser when she tried to restrain Wright. Kim Potter has pleaded not guilty to first and second-degree manslaughter charges. All right, joining me now to help us break this all down, because it's a lot to break down and understand, of course. We bring in our panel. We got Deputy Executive Counsel to Louisiana Governor John Edwards, Leslie Ricard Chambers. We also have Attorney William Wagstaff III. He's no stranger to BNC. And, of course, our BNC Chief Legal Correspondent, Laura McNeil. It is a pleasure to have all of you, and thank you for taking the time out to help us understand this complicated case. So, William, you are the odd man out. We'll start with you, sir. What can we expect from this trial?
Well, I think this is going to be interesting publicly to see how people react against the backdrop of what we just had with the Arbery trial, against what we had in relation to the Rittenhouse trial. And I think that this is distinctively different. And for me as an attorney, it's a bit intriguing, because the law here is going to be very difficult, in my opinion, for the prosecution to prove. They have two counts. They have the first count, which they're going to need to prove recklessness if they're going to prove that. And I don't know that you can say that something is reckless if the jury believes that she actually mistook and was mistaken about having an actual taser versus a gun. I don't know that you can be reckless if you don't realize that you even have a gun in your hand. As it relates to the second count, you have to determine whether or not there was unreasonable risk. And when you look at the risk, if she genuinely believed that he was trying to flee in the vehicle, was it unreasonable to grab the taser, again, assuming you believe she was using the taser? And then is it consciously taking the chance to cause death if you genuinely believe that you have a taser? So I am kind of, as a legal geek, interested to see how the prosecution handles, which I think is a difficult case.
Laura, what are your thoughts? How do you think they'll handle this?
You know, for the first time in history, I actually disagree. I think that they do have a strong case. I think they can make the argument that Officer Potter, meaning the prosecution, was reckless. Reckless because she's not a rookie. She's a trained officer. As a matter of fact, she was in the process of training another officer when the shooting occurred on how to use force when necessary. And the fact that I'm supposed to believe that she mistakenly picked her taser as opposed to her firearm, you know, I have had the opportunity to do police training, implicit bias training, but in that training, I've had a chance to actually hold a taser. They're very light, almost feels like a plastic gun. The weapon itself is very heavy. There's a distinct difference. And so I think that it will be easy for the prosecution to establish that, you know, she had a responsibility and she was reckless, and that she endangered the life of Daunte Wright, and that recklessness was unreasonable for someone with her level of experience, and that she should be held responsible at a minimum for second-degree manslaughter. Not so sure about that first degree.
Yeah, just to piggyback off of that, Laura, law enforcement experts say, you know, your service weapon is usually on your more dominant side, so you don't get your taser and your gun confused. Leslie, what are your thoughts about this? What if this was an officer in your state?
Oh, well, I'll tell you this, from the jury selection perspective of what's going on in that courtroom right now, we've already heard potential jurors talk about the fact that they don't agree with the concept of defunding the police. And there are even potential jurors who have even discussed that police officers have a difficult job. And so I think that we've got to discuss this holistically to consider what William legitimately discussed at the top of the hour, as well as some of the points that Laura made, but then also understanding that when we're talking about proving a case beyond a reasonable doubt, that the jury has to believe beyond a reasonable doubt that she committed her acts with a reckless disregard for human life and a reckless disregard for the potential to commit great bodily harm. And so far, it sounds at least as if there are a couple of jurors who believe that police officers, A, have a tough job as it is, and B, that their concept of what they believe to be defunding the police, or at least the title, is one that causes some I guess, uncertainty or some reason of uncomfortability with these potential jurors. So that's something that we've got to think about as they continue to select these jury persons.
Yeah. William, I mean, this is another situation where we are actually seeing this person, Daunte Wright, 20-year-old unarmed black man, murdered. I mean, just being pulled over. Talk about how important this video is, and also the words of Potter herself, where she says, I mistakenly pulled the weapon and I'm going to prison. How important is that going to be for this trial?
And that, truthfully, is what changed my perspective. When I first heard about the case, I was of the belief, okay, you've been on the force for a period of time. You're not a rookie. The weight difference, I have also trained police officers and know that they have the taser on the non-dominant side. But what for me was interesting, or which kind of shifted my perspective a bit, was what we would consider the excited utterances, where she was saying, I'm gonna tase you. She shouts out, taser, 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 which is generally a command that you would give, or you would be shouting that to let your partners know that you're about to deploy the taser so that they don't get hit accidentally. And then she's still saying, I'm gonna tase you, and then she shoots it one time, not multiple times, where she's just firing off. And if you're saying that she should have known the difference, or you're trying to impute criminality, then that means she was calculating this throughout. You're then accusing her of calculating this throughout and saying on the body camera, setting the tone, taser, 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 and then even at the end, the OS, and I'm going to jail. To me, those happening contemporaneously with the actions make it a little bit hard of a sell to me that this was a calculated murder.
Yeah. Laura, are we going to go for two with you disagreeing with William on that?
No, I think William has made some excellent points in terms of that excited utterance, and that will make an influence on the jury. I think, again, if I was prosecuting this case, though, I would really focus on the fact that she took an unreasonable risk with that firearm, that she was a seasoned police officer, and she was reckless. And so I don't think, again, that first-degree manslaughter charge has a chance, but I will put my bets on that second-degree manslaughter charge.
So, Leslie, I want to actually direct this next question to you, right? All right, so jurors have been presented with race-related questions. Are they appropriate?
I think that when you think about the concept of the Batson challenge and ensuring that folks can be fair and impartial, you have to ask those questions, because if we can all remember, this is one of the incidences that occurred during the weeks, months, if you will, after the George Floyd incident, and then, of course, all of the other incidences that occurred across the country relative to Ahmaud Arbery, relative to Kyle Rittenhouse. And so you have this cluster of scenarios happening across the country involving Blacks, minorities, and police. And so the questions that are being posed to the jury really are testing their level of reasonableness, if you will, because reasonableness is shaped by our life experiences as well as our ideologies. And so not necessarily knowing what those specific questions are related to race, I think it is reasonable for both the prosecutors as well as the defense attorneys to ask them poll questions regarding their perspectives of the climate, regarding not just social justice, but also police relations within those communities. And so those answers are going to be relevant to both sides to determine whether or not they're going to use a challenge for cause or a peremptory challenge to remove any potential jurors from this case. because we've got to establish that fair and impartial jury, right? And the only way to do that is to ask those hard, tough background questions.
Yeah, and that actually brings me to you, Laura, because I know you have a background in implicit bias training as well. You mentioned it earlier. So what type of responses would get someone kicked off, get someone kicked out and not put on this jury?
Yeah, Tashani, essentially any response that shows that those jurors cannot be fair and impartial, that they cannot come to that jury stand with what I like to call a clean slate and be open to just listening to the facts and applying it to the law. You don't want a situation where jurors are coming in with preconceived notions, where they already have guilt in their minds or not guilty in terms of Kim Potter. And that's why they asked the jurors, for example, have you heard of Daunte Wright? What are your perspectives? Are they positive? Are they negative? Explain. Have you participated in any Black Lives Matter protests or demonstrations? And so they're just trying to make sure that they can uphold the Constitution and that that defendant, which in this case is Kim Potter, gets a fair and impartial trial.
All right, and there are reports that one juror has been seated so far in this trial. We'll continue to follow this, of course, and bring any updates once others are seated as well. All right, William, so we'll go to you. What's the defense's strategy? And talk about how they'll be able to actually convince the jury for an acquittal.
Well, one of the things that they've kind of leaked is they seem to want to go down the path of a self-created danger because Daunte tried to drive away and was essentially resisting arrest, and they had him outside of the vehicle. He starts to pull away and then starts to jump into the car. If you take the perspective that that vehicle, if he's trying to flee, then becomes a weapon, he could have potentially hit the officer that was in the doorway while he was trying to jump into the vehicle. I think that that definitely changes the dynamic of the encounter. Where I would be careful if I'm the defense is I think if this was motion practice, where you're putting those sorts of arguments before a law clerk or before a judge who may not have the same tendency as a layperson to get caught up in the emotion of or feeling sympathetic for Daunte, that would be a viable defense, that, hey, this is a self-created danger. You can't create the danger and then turn around and then accuse the person responding to the self-created danger as a murderer or somebody that took your life and that there's criminality associated therewith. However, I think in front of a jury, there is going to be sympathy for him. I think that you have to look at the climate that we're in and the temperature in the room. And I don't know that that would be the best approach. What I would recommend is, again, speaking to the evidence. The evidence is that that was an excited utterance, that she legitimately believed that that was her taser, and then kind of flip it on the prosecution to rebut that and make them prove that she was not mistaken, that she actually knew that she had her firearm and that this was a confected situation. It's very different to me than what happened in the Arbery case, where when the guys were first apprehended, there was no mention of the citizen's arrest. There was none of this. They were very lax. And then it seemed Monday morning quarterbacking that defense counsel started to talk about self-defense, where that wasn't the case. Here, from the outset, before there were lawyers involved, before there were charges, there's indications that she was mistaken about what was in her hand.
All right, Laura, we'll end with you. Final word.
Final words for me is that this trial is long time coming and waiting, and I think it's really going to be a very different vibe than we saw with the George Floyd hearing. And what I mean by that, the trial for Derek Chauvin, is that I think because we had a 20-year-old in a situation, as William said, that unfortunately contributed to the escalation of things, that it might change the jurors' hearts. We'll see.
Yeah, and you know, I actually should have mentioned this earlier, but another well-known case where an officer mistook his service weapon for a taser, or vice versa, I think I said that the opposite way, was Oscar Grant. You remember back in 2009, the movie Fruitvale, and unfortunately there was a civil suit in that. Thank you all for joining us. It was a pleasure having you.